Hi, everyone. I'm Amanda Tuminelli. I'm the Executive Director of the DeFi Education Fund, and it is my honor to introduce Matthew Galeotti, the Acting Assistant Attorney General of the Criminal Division of the Department of Justice. In that role, Matt oversees over 1,000 prosecutors and staff investigating and prosecuting all different kinds of crime, including violent crimes, trafficking, money laundering, and cybercrime. And before that role, he was in the Office of the Deputy Attorney General. And before that, he was the Deputy Chief of the Business and Securities Fraud Section in the U.S. Attorney's Office in the Eastern District of New York, where he also investigated and prosecuted complex securities fraud and abuses of the traditional financial and digital assets markets. And before his government service, he was in private practice at a big New York City law firm doing white-collar criminal defense, where he defended both companies and individuals. So Matt's going to make a few comments about Department of Justice policy and of particular interest to us in this room on money transmission laws and money laundering laws. And we will do a Q&A later after Matt's speech and after a brief intermission. So please join me in welcoming Matt to the stage.
Good morning, everybody. Thank you, Amanda, for that introduction, and thank you to the American Innovation Project for hosting this conference. As Amanda said, our job in the criminal division is critical, and we enforce all kinds of laws, from violent crime to child exploitation to human trafficking, but also financial fraud and money laundering. And I know this is of particular interest to this audience. We are also focused on rooting out bad actors from the digital asset ecosystem. We're doing that so that responsible innovators can build and users can act with confidence to take advantage of the opportunities presented by these new technologies. The digital asset industry plays an increasingly important role in innovation and economic development of the United States. As digital assets become more commonplace, providing a safe environment for well-intentioned innovators and digital asset holders is central to our economic and national security. That's why our Deputy Attorney General, Todd Blanche, asked me to come here to speak with you today about the Justice Department's focus on even-handed enforcement of the law that allows good actors in the digital asset space to continue to flourish, while also ensuring bad actors who misuse this technology are held responsible. It is our job as law enforcement officers to provide fair notice and clarity around our enforcement policies. That's why I'm here today. In April, the Deputy Attorney General, more commonly known as the DAG, issued a memorandum to the department's prosecutors around the country, including those in my division, which makes plain that the Justice Department's role is to enforce criminal laws. We are prosecutors, not regulators and not legislators. Our job as prosecutors is to follow the evidence, apply the appropriate legal framework, and to seek justice. As prosecutors, we are also governed by the Constitution, and in particular, the right of due process. Criminal laws must give fair notice of what is illegal. As the Supreme Court has held, when the government prosecutes someone under a criminal law, quote, a defendant generally must know the facts that make his conduct fit the definition of the offense. The Deputy Attorney General's memorandum recommits the department to these bedrock principles. The department will not use federal criminal statutes to fashion a new regulatory regime over the digital asset industry. The department will not use indictments as a lawmaking tool. The department should not leave innovators guessing as to what could lead to criminal prosecution. We know that the industry continues to seek clarity from the department on its policies. We've received letters and presentations from Defense Counsel that raise concerns about holding developers of smart contracts criminally liable for operating unlicensed money transmitting businesses. We've heard arguments that against imposing criminal liability on those who publish code and are not otherwise involved in peer-to-peer transactions. These are complex questions of law and fact, and the criminal division will continue to rigorously evaluate each case and to make sure our actions are consistent with the letter and spirit of the Deputy Attorney General's guidance, which I've also got incorporated into my guidance for criminal division prosecutors. Our view is that merely writing code without ill intent is not a crime. Innovating new ways for the economy to store and transmit value and create wealth without ill intent is not a crime. The criminal division will, however, continue to prosecute those who knowingly commit crimes or who aid and abet the commission of crimes, including fraud, money laundering, and sanctions evasion. When bad actors exploit new technologies, it undermines the public trust in those technologies and stifles innovation. And a technical but important point here that I want to be clear about. To be guilty of aiding and abetting a crime, one has to intend to aid the commission of an underlying crime. It requires specific intent. So does conspiracy. Therefore, if a developer merely contributes code to an open source project without the specific intent to assist criminal conduct, aid or abet a particular crime, or join a criminal conspiracy, he or she is not criminally liable. When it comes to criminal prosecution, involvement in the digital asset ecosystem should not and will not subject individuals to a different level of scrutiny. It also does not provide someone with any more or any less protection from money laundering, sanctions evasion, and other criminal offenses. Criminals will be prosecuted whether their tools are old or new. However, these tools must not be misused to target the lawful activities of law-abiding citizens. The law is technology neutral. So under the Deputy Attorney General's and the Attorney General's leadership, as the DAG memo states, the department is simplifying things to hold bad actors accountable while avoiding the prosecution of unwitting regulatory violations. Let me get a bit more concrete, and I know it's of interest to this crowd, in particular with respect to the department's use of 18 U.S.C. 1960, the statute that prohibits unlicensed money transmission. Here are the key points on that topic. As the DAG's memo makes clear, the Justice Department will not charge regulatory violations in cases involving digital assets, like unlicensed money transmitting under 1960 B1A or B, in the absence of evidence that a defendant knew of the specific legal requirements and willfully violated it. We may, under certain circumstances, bring cases under 1960 B1C, which prohibits the transmission of funds that the defendant knows are derived from a criminal defense or are intended to be used to support unlawful activity. However, going forward, consistent with principles of notice and fairness, let me make the following clear. Many developers have relied on regulatory guidance to suggest that non-custodial cryptocurrency software does not constitute an unlicensed money transmitting business. While that guidance may not be binding on the department, its implications can, of course, factor into prosecutors' charging decisions. Therefore, where the evidence shows that software is truly decentralized and solely automates peer-to-peer transactions, and where a third party does not have custody and control over user assets, new 1960 B1C charges against a third party will not be approved. Though, if criminal intent is present, other charges may be appropriate. All of a subject's conduct and the services they provide end-to-end will be considered. And two, generally, developers of neutral tools with no criminal intent should not be held responsible for someone else's misuse of these tools. If a third party's misuse violates criminal law, then that third party should be prosecuted, not the well-intentioned developer. These principles should provide solace to good actors and should be cold comfort to bad actors. Plenty of innovators, of course, want to responsibly and lawfully create value, but those with criminal intent may be liable for money laundering or potentially other unlawful activity, sanctions violations, or other applicable laws. Our job as prosecutors is to root out bad actors from markets, including the cryptocurrency markets. Embezzlement and misappropriation of customers' funds on exchanges, digital asset investment fraud scams, hacking activity, exploitation of vulnerabilities in smart contracts have no place in fair markets. They undermine efforts to innovate and keep the digital assets industry from reaching its full potential. Those crimes are our focus, and we continue to take that work seriously across the criminal division. By way of example of what we're working on, there are three cases we've recently announced. One was the prosecution of multiple members of a China-based money laundering syndicate being run out of the Los Angeles area that laundered millions of dollars belonging to innocent victims who fell prey to cryptocurrency investment scams. Two, we announced the filing of a civil forfeiture complaint against $225 million linked to cryptocurrency investment fraud and money laundering schemes to recover funds for victims. A third, the prosecution of a defendant for a Ponzi scheme that falsely promised investors sky-high profits from investments in cryptocurrency markets, purportedly using trading robots powered by AI. That's the kind of thing we're working on. So it's good to have this discussion with you here at the American Innovation Project. The digital assets industry has a critical role to play in this fight to protect the digital assets ecosystem from bad actors who would exploit consumers and enrich themselves through theft, scams, or other attacks. The organizers of this conference have told me that no one is more committed to rooting out bad actors than the software developers, users, and others right here in this audience, but that well-intentioned innovators should not fear for their liberty. That's common sense on both counts. Thank you for your time.